the court has appeal in the matter of Moorwand Ltd and Hamblin and others.
The Lords, upon the learned friend begins, may I crave your Lordship's indulgence for a little housekeeping?
Yes.
Just to say that, as promised overnight, our side have provided the court with the specific directions 20 and 21 from the
Thank you very much.
Services Regulator. I'm afraid the way they appear on the website is with track changes still there. I thought it wrong for me to accept the changes, as it were, to get a clean document. So the court has got what's there. We've also provided copies of the Payment Services Regulations, which were in the repealed form in the bundle.
Yes.
So there are now the full
Thank you.
The learned friend has also provided various documents overnight. I'll leave him to introduce those.
Thank you.
Your Lordship, I've put a hard copy of my note that I provided to my learned friend overnight.
Thank you very much.
Your Lordship, I've also provided in tabular form what I consider to be pertinent paragraph references to the learned judge at first instance judgment, with the paragraph number and the page number. The judgment at first instance is lengthy, and I thought it might help the court.
So you put this forward as being the steps to reasoning?
Yes.
Of the first judge?
Yes. It's just because, if I may say, the judgment of His Honour Judge Wayside could be described as unwieldy, and I've simply extracted what I think.
Well, I don't know. You've been living a charmed life. See the judgments that we spend most of our times working with. It's a remarkable judgment, Judge Wayside's judgment, for its clarity and punctuality in the circumstances. But this will no doubt be helpful if you want to use it. And in further news, the parties have spent £1 million, and so this appeal is really about who's going to pay the costs.
Well,
that's the further information you've given us.
Yes, Your Lordship, yes. Well, that's very regrettable. I could say that on our side, my clients have cost protection as far as our fees are concerned, in the normal way. But obviously they are at risk of the other side's costs.
Yeah.
But yes,
well, I'm not doing more than just stating the fact at the moment. Thank you all for the work that's gone on overnight. Appreciate it.
Yes, and Your Lordship, I've also provided the money laundering regulations. They are 2007 regulations, and I've also included two provisions in the 2017 regulations. Regulation 33, which is referred to in the joint experts report, and provides for the enhanced monitoring regime after June 26, 2017. And I've also put in the case of Bank of Liverpool and Underwood, which is of interest in the light of some discussion that took place about does it matter if an inquiry would have yielded a false answer? And we say that case says that the inquiry must be made, it's to be assumed that a correct answer is given, but in any event, if the inquiry is not made, it's not an answer to say, if we had made the inquiry, we would have received a lot of lies, and the transaction would have gone ahead anyway. So,
well, you'll take us to that.
I'll take Your Lordship to that. Yes. So, Your Lordship, I don't think I need to say anything about the note that I've submitted. I think on the first point, to be clear on the company law point, that was the start of my learned friend's submissions. the new material in the company law point are the company law, the Companies Act statutory provisions, and the cases that he took you to yesterday. None of that was raised previously. I accept that attribution was raised, authority was raised, but everyone proceeded on the basis, which is undoubtedly the case, that on the construction of the business account agreement, Moorwand believed that the genuine Mr. Stanfield was the contracting party, and
the signatory, not the contracting party.
But he was, in truth, not the contracting party.
No, nor did he purport to be the contracting party.
He didn't purport to be the contracting party.
It was RND.
But they believed him to be so.
So they believed him to be the authorised signatory and director of the contracting party.
They did, and that was never an issue. That was how they proceeded, I dispute that Mr. Justice Marcus Smith made any fundamental error in his appreciation of the position. When he said, I think he deals with it at paragraph 4B of his judgment, where he says at page 107, Your Lordships, in the bundle,
Which subparagraph?
Subparagraph B, Your Lordship, at
Thank
the
you.
top of
Yes.
107. Where he says the person authorised to act for R&D was a Mr. Stanfield, a real person who was himself the victim of identity fraud. See paragraphs 15(1) to 3 above. There was a great deal of material to suggest that the person in fact purporting to act for R&D was not Mr. Stanfield, hence my use of quotation marks around Stanfield. The judge failed to attach weight to these factors by treating the agent acting or purporting to act for R&D as indivisible from R&D. Thus, the judge treated all the acts by the unknown fraudster masquerading as Mr. Stanfield as those of R&D. Again, for reasons I've given, this was an error of law. I think Your Lordship was simply, Mr. Justice Marcus Smith was simply reiterating the points that he'd made previously at paragraphs 1 to 3 above, where he said that it was a mistake to say that the R&D's agent, the acts of R&D's agent, was to be equated.
And would that be the case, whoever one treated as the agent? It wouldn't matter whether it was Mr. Stanfield, in inverted commas, or X.
Precisely so, Your Lordship. Yes, because
The gist of the second judge's position was that there was a difference between the company, however hard it is to get your head around this, and the fraudster who'd set it up for the precise purpose of fraud. And it was that gap that was not observed, so that even if one was to disagree with the judge as to who the identity, whether one should be focusing on, quote, Mr. Stanfield or X, it's the difference between individuals and company.
Indeed, Your Lordship.
In a sense, that only matters if there's no objective apparent authority.
Well, yeah, Your Lordship. If there's no, if there's nothing to put Moorwand on inquiry, then they can rely on the apparent authority of the agent.
So why does this provide a basis to reopen the trial judge's assessment of whether there was
because the judge all throughout thinks of R&D as a fraudster. He says that R&D's intention right from the outset was to trade in Bitcoin. He ignores the fact that R&D was represented to Moorwand that they were in website design and market consultancy. He treats R&D as the fraudsters throughout, and he makes that very clear. What His Honour Judge Rayside doesn't do is he elides the fraudsters with R&D.
But he doesn't find that there was actual authority to give these instructions, not least because no positive case was advanced that there was. Non-admission was made of authority. He finds there was apparent authority. Now, if he's right about that, this point of the fraudster being a different person from the company and not having authority to act for the company doesn't arise. So my question is, why is this the entry point that allows Mr. Justice Marcus Smith to revisit the evaluative conclusion of His Honour Judge Rayside?
Well, because the way that His Honour Judge Rayside reasoned was that because it was controlled by fraudsters, and because the fraudsters were to be identified with the company, and because they always intended, he found, to trade Bitcoin, the Bitcoin transactions were to be disregarded. And they weren't suspicious because that was what R&D always intended to do. I say that there were factual, I say His Honour Judge Rayside wasn't on the facts entitled to say that R&D intended to trade Bitcoin from the outset because there was absolutely no evidence that that is what Moorwand believed. Moorwand believed that they were a marketing consultancy. But because the judge, His Honour Judge Rayside, identified the R&D with the fraudsters, we say incorrectly, and because the fraudsters always intended to trade Bitcoin, he said, well, the Bitcoin transactions are irrelevant. And that, in my submission, was an error of law. I mean, it was wrong on the facts because there was no evidence before the learned judge that they intended to trade Bitcoin from the outset. As I said, Moorwand were told, and they checked it in an email, that there was going to be a marketing consultancy. And Mr. Justice Marcus was quite at liberty to say, and correct to say, that there was a disconnect between trading as a marketing consultancy and the nature of the transactions that went through in the 2-week period. And he was supported in that by the joint single expert. And in my submission, he reached that conclusion very easily. I mean, they said that they were setting up a web design and marketing consultancy, and yet in the space of 2 weeks, the numerous Bitcoin purchases were made, and the judge himself accepted that Bitcoin, he said at paragraph 113, he said, I accept that normally Bitcoin purchases and purchases of watches are indicia of fraud. He accepted that, but he rejected it in this case because he identified R&D with the fraudsters. And I say that that was contrary to authority and wrong.
He rejects it because he goes through the pattern of payments and says the watch transaction viewed in context was not so significant as to stand out.
Well, but that's because he accepted, because he found that the Bitcoin account, that the account was set up to trade Bitcoin. But he impermissibly disregarded the onboarding process because he felt that that was to do with money laundering and that everything that happened in relation to money laundering was to be disregarded. So he disregarded the declared purpose of the account and said that if I disregard that, it's obvious the account was set up to trade Bitcoin, and the Bitcoin purchases were entirely innocent. And I say that he made, the learned judge at first instance made errors of law in disregarding the purpose of the account, in having accepted in saying that the purpose of the account was to trade Bitcoin, when there was no evidence to that effect, and having accepted that Bitcoin transactions and watches were indicative of fraud, then to go on to say, oh, well, I'm disregarding the Bitcoin transactions.
But that's a challenge to the judge's findings and inferences of fact. I mean, you say there's no evidence to support them. It's not an issue of law, is it?
Well, it is an issue of law, because the reason that the learned judge disregarded the Bitcoin, well, it's an issue of law because the learned judge identified the fraudsters with the company and didn't separate them out. He felt that the whole purpose of the company was to trade Bitcoin, and
what was the purpose of the company?
well, the purpose of the company, as far as Moorwand was concerned, was a website design. It's a page.
Yes, that's what they were told. But what was the actual purpose of the company?
Well, Your Lordship, we don't know that, but I mean, I think it was set up to probably launder money from the CX scheme. I mean, I think that's fairly clear what the purpose was. It was part of the fraudulent scheme to launder money, just as in the Brinks-Matt case, the purpose of the company there was to launder the proceeds of the gold bullion.
Where in His Honour Judge Rayside's judgment is perhaps the best or clearest illustration that his findings that Moorwand wasn't put on inquiry were vitiated by some error of law of identification of R&D with the false Mr. Stanfield, if I can call him that. You know what I mean.
Well, well, Your Lordship, if in fact I take my note of the extract from the judgment, so paragraph 38, he says that one can infer that was the reason why R&D found them an attractive company to go to. There he's identifying R&D with the fraudsters. And then at 40, the fact that R&D used such an account to trade Bitcoin, that is, from the outset was to be expected, despite the basis of R&D's business. That, I say, was an error of law, because as far as Moorwand was concerned, they didn't have that expectation.
But isn't this premised on the fact that Moorwand set up 3 accounts for R&D, one of which was a Bitcoin account? So it's not surprising if a Bitcoin account is used to trade Bitcoin. Well, isn't that what he means?
Well, there was no. I mean, they also set up a Euro account.
Yes.
The circumstance in which they came to set up the Bitcoin account, the Euro account, and the Sterling account were not in evidence. The disclosure says, as far as they were concerned, this was a marketing consultancy. So it's true that they do set up a Bitcoin account. There's no disclosure or evidence as to why they did that. To say that they expected Moorwand to trade on the Bitcoin account, R&D to trade on the Bitcoin account, is an inference that I suggest that was not permissible. So at 64, looking at my notes, 64, ML rightly admits that called into question the veracity of the Unicom invoice, but says that that is part of the regulatory process and not relevant to any duties ML owed once that account was operated. I say that was an error of law because he completely disregards the onboarding process.
So I understand that point, and I understand you say there was an error of law in failing it. I think what you would prefer me to call the Philip duty rather than the Quince care duty was breached. You say there was an error of law in not looking at the account opening circumstance.
Yes.
But you also say there was an error of law in some form of identification between
Yes.
X and R&D, and at the moment I'm struggling to find that. I see you make criticisms of the judge's factual inferences, which would need, in effect, to be perverse before they could be challenged.
Yes, well, Your Lordship, so I say that where the judge makes comments like R&D was a fraudulent sham, that the learned judge at first instance was failing to distinguish
He's
between
picking up language
court.
you yourself use in your pleadings and skeletons, don't you?
No, Your Lordship, I didn't, with respect to, I didn't use the phrase fraudulent sham in my pleadings. We plead that R&D was incorporated. It's never been. It's always been our case that that the corporate entity should be distinguished from the actions of the fraudsters, and that was, in my submission, is clear from Singularis and clear from, I would submit, the Winksmack case that preceded it. So, and Your Lordship, I have never, and I have never, because we have always said that the phrase fraudulent sham has been used by Moorwand is wrong in law.
Well, if it's suggesting that the company didn't exist, it's plainly wrong. And
Yes.
I do not understand anyone to suggest otherwise on this appeal, or indeed, frankly, at any stage in the case, because there was a contract both sides averred between RND and Moorwand.
Yes.
If the phrase is used to describe the fact that it was carrying out no genuine business at all, I don't understand that to be controversial.
Well, that's slight. Well, maybe this is a question of semantics, but that's not how I would understand fraudulent sham to be to me. But continuing at paragraph 64, the judge again identifies R with the fraudsters. R&D needed to fraudulently set up an account with ML in order to get around the regulatory rules in order to trade Bitcoin. So he looks at the intention of R&D. 69, R&D had only one intention, and that was to obtain funds in order to pay them out essentially to the Bitcoin market. So he doesn't distinguish between the actions of the position of the company, which I agree is somewhat an artificial one, as the Court of Appeal said in Winksmack.
Well, it seems to involve the proposition that a company can never in itself be guilty of anything. In other words, that companies are either neutral or innocent by their natures. I mean, the fact that a company is set up for a specific fraudulent purpose your argument leaves open the possibility that no company can ever be fraudulent. It's only
Your Lordship, I would respectfully disagree with that. Where a company does something that is within its business, but does it in a way that's improper, then clearly the company is liable for the actions of its agents.
Yes, but I'm just interrogating the concept of an intrinsically fraudulent company.
Well, Your Lordship, I think that is what the Brinks-Matt case was, an intrinsically fraudulent company. That, as Your Lordship remember, their Scandin was set up to process the bullion from the Brinks-Matt robbery. The argument was put that you should strip away the veil of incorporation and you should identify the company with the fraudsters, and that was rejected. The Court of Appeal said that, strange though it may sound, and they agreed that it was rather counterintuitive, company was the victim because it no longer had the assets available to pay its creditors, but they said that there was to be no attribution in that case to the. I will take Your Lordships to that case, but the Court of Appeal recognised that it is a counterintuitive concept to describe the corporate entity which is being manipulated by the directors for fraudulent.
I'm not talking about it being manipulated. I'm talking about it being itself fraudulent, that it involves having to go through the exercise of saying that no company can of itself be of a fraudulent character because, for example, you're not allowed to set up a company with fraudulent, by stating that this is a company for fraud. I understand that. But if the reality of the fact is that it is being set up for fraud, it involves the law taking a view which is that actually, even if the reality is that it is an intrinsically fraudulent company, there's no such thing known to the law. I mean, that's what I'm understanding Brinks-Matt and your submission to say. I mean, because it may be right, and if it's right, in any case, it will be binding. But it's a curious thing that every human person can, at least in principle, be found to be fraudulent. But it would seem that no company can.
Well, Baroness Hale touches on this in Singularis, where one of the arguments was that if Singularis had been a person, Singularis wouldn't have had a remedy because Singularis would have made the payment directly. And Baroness Hale said, well, incorporation does carry consequences, and that...
She does indeed say that. Lord Legate in Philip is keen to disclaim any suggestion that his formulation of the law gives rise to differences between natural...
Yeah, but in fact, Your Lordship, in Philip, the example he gives is actually a very narrow one of an individual having an attorney. He says this principle, it applies to agents, and where an account is operated by an agent. It's a concept in the law of agency, and by the by, that's why I somewhat criticise how the learned judge at first instance formulated the duty, because it's a duty in agency. Once you're put on notice that an agent is acting without authority, then you have a duty of inquiry.
Yes, and you're further going to go on to show us that it doesn't matter if the duty of inquiry is completely lacking in any meaningful content. Namely, that you're put on a duty to make an inquiry that couldn't possibly lead to any sensible result. And so, I mean, the second judge's judgment ends at the point where he said the company was put on inquiry.
Yes.
Consequence, you win. But even though the inquiry would have been, so far as I understand it, completely and utterly pointless. It's a strange state of affairs.
Well, Your Lordship, I think there were a number of answers. Well, the one answer is that is what Lord Phillips says, and the inquiry is a matter of law, and if you don't make the inquiry, the consequences are that you're fixed with the fact that the transaction was made without authority. In the Underwood case, they say one doesn't need to speculate what the answer to the inquiry would be. In fact, in that case, they postulate that if an inquiry had been made, it might have been helpful.
Isn't one of the problems here that for a long time we've talked about this as a duty, but it operates at two levels. At one level, it's a duty only in the way that we speak of a duty to mitigate. Not that it gives you a claim, but the failure to do it prevents you from being able to make an assertion of a certain kind. And the assertion you're unable to make is I relied on the ostensible authority of the agent, and the reason you can't do that is the facts as they were without more suggested that the agent wasn't entitled or may not be entitled to do this. And I have to say, for my part, I have no difficulty looking at that and saying, well, it doesn't matter. If you'd phoned the principal and said, is he authorised to do this? He would have said yes. Got no difficulty with saying, you didn't do that. There was no ostensible authority. End of story. You've also got the duty being used to claim damages, i.e. more than simply restoring the money to the account, but the customer saying, and had I been told of this, I would have found out about this fraudster and dismissed him and avoided further defalcations. And there, I think the answer given to the inquiry does matter, because it's a link in a counterfactual causation chain between breach and loss. But I think we're only concerned with the former of those two states of affairs, and I think it's pretty clear on the basis of Lord Legate's analysis, it doesn't matter what the result of the inquiry would have been.
Yes, and I meant to say, in answer to my Lord, Lord Justice Jackson, that if the inquiry does matter, because if Moorwand hadn't made the inquiry of open inverted commas, Mr. Stanfield, close inverted commas, and received a convincing answer and they said, yes, my marketing supplier is going to purchase Bitcoin and I've had specific instructions to do that, then Moorwand would have satisfied the duty of having acted as a reasonable payment service provider. So the position does change because the inquiry has been made and the response will then be analysed.
Well, because what changes is the objective facts on the basis of which you conclude is there ostensible authority now include the answer given to the inquiry.
Indeed.
And so by definition, if the facts have changed, the answer might change as well.
Indeed, Your Honourship, and the answer might be, and indeed that's exactly how they analyse it in Underwood. They say that probably he would have said this, but that might have led to more questions. So the inquiry, inquiry need not stop with one question, but the factual position has changed. But if you don't make the inquiry and you're put on notice, then the agent has in fact no authority, then the account can't be debited. Yes, so to answer my Lord Justice Foxton's question, I think the learned judge at first instance, by simply accepting that the Bitcoin transactions were to be expected, it is fixing R&D with the knowledge, with the identity of the fraudsters, because that's the that's the basis upon which the judge says that the Bitcoin transactions were. So at 113, Your Lordship, I put the extract at page 4 of my note. Well, he says the purpose of the watch was a one-off transaction. It had been said in the context of all the transactions taking place, including those permitted on the Bitcoin, but I generally accept the comments made by John that watches and Bitcoin transactions are typically associated with fraudsters. So on the face of it, Bitcoin trading, but he says that may be so, but the facts of this case have to be considered with the above transactional background, which in my judgment would not give rise to any reasonable concerns by ML who have provided a quite separate account for the purpose of trading from the outset. That's where are generally traded. But he has ignored everything that ML has said about the nature of its trading activities. Sorry, not that R&D has said about the nature of its trading activities when in coming to that conclusion. So, so yes, I mean, so in my submission, the judge doesn't clearly differentiate between the company and the activities of the fraudster. It may be counterintuitive, and to say that the company is an innocent victim in this instance, but the reason for that is the company was a trustee, held the money on behalf of Mr. and Mrs. Hamblin as trustee, and its assets were divested. It doubtless had other creditors, because I think other people put money into the R&D account, and they couldn't be repaid. So they were victims. So the learned judge at first instance says this is a derivative action, and that's where the troubles for Mr. and Mrs. Hamblin start. I say that that's an error of law because R&D is to be treated as a victim. R&D is a corporate entity. It has a rather small, narrow existence.
Yeah.
But it does exist, and it was a trustee, and it now got an administrator appointed over it. It exists, and
what he means by saying that's where the trouble starts for Mr. and Mrs. Hamblin is they can't be in any better position than R&D was. He's right about that.
Yeah,
he is right about that.
He's undoubtedly right about that.
Yes, and then, as I read his judgment, the basis for his decision is his assessment that these purchases were not such as to put Moorwand on notice, with the consequence that R&D is stuck with these transactions because of the ostensible authority. And if his factual assessment is correct, the consequences follow that R&D is stuck with these transactions, and Mr. and Mrs. Hamblin are no better off. So the attack on the judge's judgment, it seems to me, has to concentrate on whether his assessment that there was nothing to put Moorwand on notice was one that was open to him or not. And that doesn't depend upon the singularis point or
Your Lordship, I accept what Your Lordship says, but It featured very heavily in the submissions on behalf of Moorwand.
That I understand.
That is a very fair comment.
But when we are sitting here on a second appeal,
Yeah.
I think our task is to go back to the original judgment and say, was the appellate court right to interfere with it or not? I mean, that's what we do, isn't it?
Yeah, well, your lordship, of course. I think, Mr. Justice Marcus Smith, we'll come to his criticisms of the way that the learned judge approached the money laundering aspect, because we say that he misapplied at the instigation of Moorwand the significance of money laundering, and he simply, as I've said before, he ignored the onboarding because he felt that he was legally required to ignore the onboarding, and he, as Mr. Justice Marcus Smith said, he paid no account of the stated purpose of the company, and he took no account of the fact, as the joint expert found, that Moorwand should have been on inquiry about the motivations behind R&D.
Yes, I mean, the trial judge, I think, very fairly comments that Mr. Burns' report is not a model of clarity. And I suspect each of you felt there was something in it for you, which may explain why nobody sought to bring him along to expand at the hearing. The judge, therefore, was left, wasn't he, with making the best that he could of what he had been said, and he reached his own interpretation of it. And the question is whether that was a tenable interpretation of a report that in part seemed to do different things at different stages between sections 5 and 6.
Well, your lordship, yes, but his view of the report, in my submission, was vitiated by his overarching error that everything to do with money laundering was to be left out of account, and that was what was urged upon him. And I say that was an error of law.
Where does he say that? What is the paragraph?
Well, your lordship, there are quite a few paragraphs where he says that. He says. Well, 128, he says, there's no complaint made of money of Moorwand. Actually, that's Moorwand in accordance with Philip and the Burns. Only regulatory concerns that may have had an impact, and this is a counterfactual question not based on any probability for civil trial, must be put in the context of very few days in which all the funds were dissipated. It's quite a long time since the fact. Quite a long period. So I put this last comment of Mr. Burns. That is the comment where he says that Moorwand should have served an SAR report because of the appearance of money laundering. He says.
I mean, 129 is his takeaway, isn't it, from the report? And he interprets Mr. Burns as saying that although there were these issues about the opening account, despite these initial shortcomings, Mr. Burns' view was there no reason to suspect any attempt of misappropriation of funds. So that's the conclusion His Honour Judge Rayside draws from the report, and I think he later on says he agrees with that conclusion.
So 130, should I satisfy the expert report cannot, as it may allow support that case, respect of the duty, although it does contain some assistance in terms of regulatory failings, this is not of any relevance to common law and contract case.
Well, the mere fact that a regulation has been breached of itself does not tell you the answer. The question is whether factually the events that led to it being breached are relevant to your assessment of whether the quince care duty or the fillet duty was breached.
Yes.
And the judge's interpretation of Mr. Burns' report at 129 sub 2 is they don't, even taking those into account, don't amount, as it were, to a reason for Moorwand to suspect a misappropriation of funds from R&D was going on when the transfers were made.
Well, Your Lordship, he disregards any regulatory breach, or he puts the regulations into a separate silo.
When you say disregards, I mean we're looking at a passage where he's very plainly regarding these matters. What is it that you?
Well, Your Lordship, if one looks at 163, he says. The duty was set out irrespective of the regulations to which he referred fully. They are separate frameworks and separate matters. He refers to regulatory matters out with the common law situation.
This is an account of Philip, isn't it? This is the judge's understanding of what was said in Philip. Is that right?
I mean, his conclusion, is it not, is at 167, where he's gone through all the regulatory failures and said, but the regulatory failure by itself doesn't give rise to a cause of action. The real question is what he identifies in 167, whether there was anything that could form the basis for a case. That is, by reference back to 128 to 130, was there any reason, despite all the regulatory failings, to suspect that these payments were an attempt at misappropriation of R&D's funds? And he reads the expert as saying no, and he says, I'm going to follow that. And it's not obvious to me that he's doing anything impermissible there.
Well, you look at he disregards entirely the onboarding process, as Mr. Justice Marcus Smith correct. So, paragraph 64. So he's talking about the Unicom invoice. Moorwand rightly admits that it called into the question the veracity of the Unicom invoice, but that is part of the regulatory process and not relevant to any duties Moorwand had once the account was operated.
That's a submission of Moorland, isn't it?
Well, he plainly accepted it.
I mean, do you say Mr. Burns was wrong to, as a matter of, and I think you do because you said we have trial by judge, not by expert in one of your submissions, but to express the conclusion that notwithstanding what went on in the onboarding process, there was no reason why Moorwand should have suspected that these payment instructions involved misappropriation from R&D.
Well, before that, he had said that they should be put on. They were put on inquiry, but he goes on to say, and I do say, he goes on to say they should have triggered an SAR report.
Well, and there's the debate about the may, but I'm going to put to you again my question, where in his conclusion, where he says not effectively, notwithstanding the shortcomings, Moorwand was not put on inquiry. You say that was wrong, don't you?
Well, I say that if you look at his report as a whole, he is saying that these transactions were suspicious and that Moorwand were on inquiry. I agree if you focus on those words. He's saying that there is, but previously he says misappropriate, but the transactions were not of the size that one would have expected for not of the size expected given the nature of the business that was communicated.
At 186, the judge says, I entirely accept what Mr. Burns says, that although he criticises the regulatory role of ML, he's satisfied there is no reason to suspect any attempt of misappropriation of funds. That is an important opinion, and one that I entirely associate with on my own findings and find myself in full agreement. So, I mean, he has nailed his colours fairly firmly to his interpretation of that report, hasn't he? The judge, Mr. Justice, he's on the judge race side.
Well, Your Lordship, but he makes the mistake of disregarding the rider that Mr. Burns adds to the report, where he says that there's a debate about whether may or should. I say that the report says that they should provide an SAR report, but the whole circumstance in which an SAR report has to be provided is if there is a suspicion of the existence of the transfer of criminal property.
Could you just help me? There's a very basic question which doesn't bear on this case, but they're called the money laundering regulations. Is what took place in this case money laundering?
With Your Lordship, yes, it is. Yeah.
Why? I mean, most people might call it theft, but I mean.
Well, it's money laundering is the dealing with criminal property. That's the definition of money laundering. Is the transfer of criminal property, proceeds of crime, and these were proceeds of crime, and so when he says that there should be a money laundering report to the authorities, he's saying that this had the appearance of the proceeds of crime.
That was just my question. You say, and it doesn't sound as if there's any argument about it, it's squarely within the definition of money laundering.
Absolutely, Your Lordship, and on a fair interpretation of what Mr. Burns said, one should take into account his rider, where he says that a money laundering report should be filed. A money laundering report is filed where the where the bank suspects that there are criminal proceeds being transferred, and that's under the Proceeds of Crime Act provisions are in the bundle.
But all of that could have been explored, Mr. Burns, if anyone had required him to attend for the trial. The question about a report which, as I say, each party has their own preferred bits of.
Well, yes, but I mean, the learned judge made an error, in my respectful submission, in saying very clearly, as he does, that he disregards the last sentence. He specifically says in his judgment that I disregard the last sentence of the report. Well, in my respectful submission, the last sentence of the report, in referring to an SAR, report, is critical because if you unpack what he's saying that a proceeds of crime report needs to be filed, and a proceeds of crime needs to be filed where you suspect where there are indicia of money laundering.
But I think your difficulty is twofold, I think. The previous sentence, he says, no reason to suspect an attempt at misappropriation. And in the substantive section of the report, he says, at least should have been considered for submission of an SAR. And so...
Well, I think, Your Lordship, before that in the report, he's rather firmer. He says that an SAR report should have been provided.
Well, there's cross-examination fodder here all round, isn't there? But no cross-examination, and the judge was left to do the best he could with what he had.
Well, Your Lordship, in my submission, there are, if one looks at the report, and Your Lordships, I give my interpretation of the report at paragraph 31 of my skeleton argument for this appeal, and I set out the passages in the report that I say should lead the court to say that in fact the report makes it clear that the joint single expert was saying that this was a situation in which money laundering was to be expected, was to be suspected, and that that's it's because the learned judge viewed the report through the lens that everything to do with money laundering was irrelevant, that he interpreted the report in the way that he did. Yes, Your Lordship. So I give my summary at page 68 of the core one. I refer to the conclusions in the report. The judge took no account of the Unicom invoice. He took no account of the business activities. He did recognise that certain types of transactions involve greater risks of money laundering. Mr. Burns said that Moorwand's processing of the transfers were not in all the circumstances fully in accord with the practice of the reasonable service provider, out of a character that R&D had previously advised. Once having been put on notice of the honesty of the client, this required greater scrutiny over transactions, and then he refers to a duty to inquire in this case, he qualifies in the summary by saying their nature and size were out of the expected character of transaction that R&D had previously advised. Therefore, it was legitimate for Moorwand to accept that the instructions were properly given under their terms and conditions, notwithstanding the shortcomings in their due diligence. But the judge at first instance thought that the report of the because he thought that the comments made by the single joint about money laundering and obtaining a SAR were irrelevant, and he disregarded the last observation of Mr. Burns as of no assistance. And also, I do say that he viewed the report through a wrong conception that money laundering was irrelevant, and that anything to do with money laundering was a separate regime and was of no relevance. And that led him to an incorrect appreciation of what the expert was saying. In my respectful submission, Justice Marcus Smith put it very clearly when he said in his judgment that at 108 107, I'm sorry, little 6. In my submission, he put the fundamental fallacy in the judge's approach very clearly at 6. The judge also erred in drawing a line between facts that went to regulatory failures and facts going to Moorwand's duty of inquiry. Whilst right to say that regulatory failures, for instance, failure to monitor for money laundering, are not relevant to the Quince care duty, it's an error to assert, as the judge appears to have done, that where facts are relevant to one duty, they are ipso facto irrelevant to another. This doesn't follow. It's obviously wrong. Whether a bank is put on inquiry is obviously a question of fact, but one that must be considered in the light of the relevant history. That history cannot be redacted because some facts which would otherwise serve to put a bank on inquiry go to other different regulatory breaches on the part of the bank. Facts may be pertinent and taken into account for more than one purpose. If I may respectfully say so, that was put very clearly by the judge, and the judge gives the paragraphs in the judgment to which he's making reference. But it's clear that Moorwand said that they were urging that anything to do with money laundering was to be left out of account. And one can see the argument reflected in the earlier judgment was left out of account, and the judge couldn't look at it, and the judge accepted that. It was put to me that paragraph 64, that's a recitation of Moorwand's argument. That's true, but he accepts the argument that anything to do with regulation is irrelevant, and that led him to reject the whole onboarding process as being relevant. Mr. Marcus Smith was also correct to say at 7, as he does here, the judge dismissed the tension between R&D's business purpose and the manner in which R&D's account was conducted, and the clear concerns arising on the opening of R&D's account for an altogether bad reason. He also dismissed the concerns identified by the single expert for the same erroneous reason. And, Your Lordship, I think Mr. Justice Marcus was entirely correct to say that. The only reference to the declared business purpose for the account made by the learned judge was in paragraph 40, which was not concerned with the Quince care duty, which was where he talked about the account being open for Bitcoin trading. He says that despite the business purpose, it appears to be open for Bitcoin trading.
Why else would you open a Bitcoin account?
Well, Your Lordship, the facts surrounding the opening of the Bitcoin account are simply not before the court. We know that there was a Euro account. We don't know anything was said about a Euro account. Moorwand could have. Moorwand didn't provide any explanation of why a Bitcoin account was open. It's pure speculation.
Well, it's a question of whether the judge can draw an inference that, most of us do not have cryptocurrency accounts, and the question is whether it was, as it were, an inference that it was open to the judge to draw, even though others may not have drawn that inference.
Well, Your Lordship, there was Moorwand have a duty to give disclosure, and they did give disclosure about the opening of the account. In none of their disclosure do they say anything about Bitcoin trading or even the provision of a Bitcoin account. It's possible that something was said between Moorwand and the fraudsters about which we don't know, but there's been no disclosure about that. There was no evidence put in that there was any discussion about opening a Bitcoin account. The mere fact that a Bitcoin account is provided, I mean, they may do it for all customers. I don't know. I don't think it's permissible for me to speculate.
But it's common ground that you accept RND contractually opened, amongst other accounts, a Bitcoin account.
Yes.
And it's then said that transactions that involved in buying Bitcoin or investing in Bitcoin from proceeds held across the account generally were suspicious transactions. And in answering that second question, isn't the judge entitled to have regard to the nature of the account opened in the first place, such as it might be different? The objective appearance might be different had there never been a Bitcoin account than if there was one at the start.
Well, Your Lordship, the court can take into account. Well, we operate on a system where parties put their cards on the table. If there was an understanding that they were going to trade in Bitcoin, there should have been some disclosure of it, evidence of it. There's simply no evidence whatsoever. I mean, one could say, was there an expectation that they trade in euro because the euro account was provided?
But it's an objective question, isn't it, about what to a reasonable payment institution in the position of Moorwand when asked to make these transfers, what would objectively you have concluded there was a suspicion that money was being misappropriated from R&D, and one factor you have is money is being used to buy Bitcoin from accounts where the account holder is a company that originally set up a Bitcoin account. That's at least one fact in the mix, isn't it?
Yes, the single joint expert clearly looks at the stated purpose of the account, so that's clearly relevant to the consideration of the matter. Clearly finds in his report that the Bitcoin trading and the nature of the activity on the account was inconsistent with the stated purpose of the account. And Mr. Justice, the judge at first instance doesn't pay any regard to that.
I'm just looking at the important sentence in the supplementary bundle at page 88, which is the conclusion of the expert's report, which, as my Lord has said, has something in it for everybody. And it really comes down to the paragraph at page 88, beginning with regard. Does it not?
Yes.
And that's what it all turns on. When the judge is considering the expert's report.
Yes. He says there was no, Your Lordship, but I say it's a mistake just to look at the last sentence. Of course, I would say.
I understand. There's a lot of criticism of Moorwand in the preceding pages. I'm not overlooking that.
Yes.
But in the end, I think the judge's reasoning seems to be it was for you to establish a different conclusion to the one that the expert is there expressing, which is notwithstanding all of the matters that he's taken into account.
Well,
As the judge picked out, no reason to suspect an attempt at a misappropriation.
yes, he does, but he ignores what I say are the critical qualifications of that the nature of the trust should have triggered suspicions of money laundering and been subject to a suspicious activity report, which may have prevented their completion. So by saying that it should have triggered suspicions of money laundering, he is saying that it has the appearance of criminal property and that it in itself, the appearance of money laundering is itself should have put the R&D on inquiry. But the judge, wrongly in my suspicion, doesn't take the sentence as a whole. He says only at the first passage and doesn't look at the concluding part of the sentence. Previously, he'd said, while the transactions were not indicative of an attempt to misappropriate R&D's funds, their nature and size were out of the expected character of transaction that R&D had previously advised. So that is the single document is there saying that the transactions were not in accordance with what Moorwand had been told.
So, addressing that issue, the judge's interpretation of the expert evidence and the conclusions that he reached about it, which is what we've been thinking about, how is that traced through the first and second appeal grounds?
Well, you'll obviously that was raised before Mr. Justice Marcus Smith, and the point has always been made that Mr. Justice Marcus Smith made an error of law in not looking at money laundering, in saying that anything to do with money laundering is irrelevant, and that it was through that prism that he interpreted the report, and that was an underlying error of law, because money laundering is indicative of acting without authority, because there is no entitlement to launder criminal property, so that the reference to money laundering should itself have put the should have put R&D on notice. So the case where to Mr. Justice Marcus Smith, he didn't find it necessary to refer to it, where the appearance of money laundering was held to put the financial institution on notice. That's the case called Credit Agricole and Papadimitriou, where there was an appearance of money laundering, and the Privy Council held that put the bank, that triggered the duty of inquiry. That case was concerned with the slightly earlier. That case was concerned with the time of opening the account. There were stolen proceeds, and the account was opened with Credit Agricole in Gibraltar, and the money had arrived through a number of different banks and had the appearance of money laundering. And the Privy Council held, upholding an appeal from the first instance judge in Gibraltar, that the appearance of money laundering was such as to put the bank on notice. Your Lordship, that's the case of Credit Agricole and Papa Demetriou, and Lord Sumption, in fact, has something interesting to say about the, when one is put on inquiry. Lordship, it's at divider 14 in authorities. So, Your Lordship, this was a case in which that there was a collection of antique furniture had been stolen, and the proceeds were paid through a series of banks. And the question is whether or not, so the proceeds were traced into the bank account with Credit Agricole. And the issue is whether the bank could say that it had no notice such as to be put on inquiry of the fraudulent origin of the proceeds. The learned judge at first instance had not asked the question of the purpose of these various transactions. So paragraph 25, Your Lordship, at page 481. So the Chief Justice had not asked himself what was the underlying purpose of the transactions. He had simply satisfied himself that of the origin of the monies. And then at paragraph 26, paragraph 29, Court of Appeal found that the claimant rightly submitted that the arrangement could not have any commercial purpose other than money laundering. No doubt it was arranged to pay Mr. Syme's debts to Citibank with the use of a web of legal entities, and the cost would have alerted a reasonable bank to the improper motive, namely to launder the money. And then a paragraph 31 at the top of 484. And Your Lordship, what Lord Sumption says about the nature of the duty of inquiry, or the nature of the obligation to inquire is of interest at page 485, starting at letter B. There must be something which the defendant actually knows or would actually know if he had a reasonable appreciation of the meaning of the information in his hands, which calls for inquiry. The rule is the defendant in this position cannot say that there may well have been an innocent explanation if he's not made the inquiries suggested by the facts at his disposal, with a view to ascertaining whether there really is. I eschew words like possible, which set the bar too low, or probable, which suggests something which might justify a forensic finding of fact. Even without inquiry or explanation, the transaction appears to be a proper one, then there's no justification for requiring the defendant to make inquiries. He is without notice. But if there are features of the transaction such that if left unexplained, they are indicative of wrongdoing, then an explanation must be sought before it can be assumed that there is none. In the present case, on the facts actually known to the bank, there was no apparent explanation of the interposition of the Palestinian and Liechtenstein unless it was to conceal the origin of funds derived from third parties. That was why the bank had to make inquiries before proceeding if there was an innocent explanation. So, Your Lordship, I say there are here features of the transaction such that if left unexplained, they are indicative of wrongdoing. The wrongdoing is money laundering, is disposing of funds for which there is no reasonable explanation.
What in practice should have happened at Moorwand? Could you just describe what you say should have happened? Well, if that is correct.
Yes, they should have said. Can we? They should have contacted the so-called Mr. Stanfield.
Can you just talk us through, based on the evidence, what's the first thing that, leaving aside the setup of the company, but we're talking about the transactions at this point?
Yes.
Right, so I'm understanding that all this is done online.
Well, we assume that, Your Lordship. There's no evidence of. We know that the processing is done through online. We don't know if there's a gap between the submission and the actual approval.
It sounds a bit strange that all this should have been done without an understanding of what happens. I mean, I'd just like to understand what a company in Moorwand's position, acting as you say it should have done. And what are the stages, and what it done? What are they doing? Are they freezing an account?
Yes,
what is suggested ought to happen?
The payment should not be made until.
As soon as somebody tries to make a payment in Bitcoin out of a Bitcoin account, if they are a business that has been identified as this business was to Moorwand, there should be some mechanism for preventing that payment leaving the account.
Yes, well,
is that the proposition?
There should be an inquiry, just as there would be a procedure for making a suspicious activity report, and the account would be frozen. So, under the Proceeds of Crime Act, there is an obligation to monitor the account, and the money laundering regulations provide for there to be a monitoring policy. They have an obligation to monitor the account, and in this case there would have been an enhanced monitoring policy. So they are under duty to monitor the account, and if they come across a suspicious transaction, they should delay processing the account until they're satisfied that it is an authorized transaction. And that's exactly what they should have done here. They should have made contact through the contact details and said, why, if you're a web consultancy, are these Bitcoin purchases being made? because they have an appearance of money laundering. And then the fraudster, we don't know what the fraudster would have said, but the fraudster might very well have not made the transaction. Well, one doesn't, that's speculation. But an inquiry such as that, or the first transaction may have gone through, but they may not have repeated the transaction. An inquiry might well have had a chilling effect on the activities of the fraudsters if they felt that they were under scrutiny. So, Your Lordship, this may be a convenient moment to look at the Bank of Underwood and the Bank of Liverpool case, where they discuss the implications of making an inquiry.
I've read the sidelined passage
Well,
in that. Is that what you take us to?
Your Lordship, yes. This was a case. It's discussed in Philip. It's a case where there were two types of check. There was a cross checks and uncross checks. The cross checks were subject to the Bills of Exchange Act and don't arise, but the uncrossed checks were subject to were not subject to the Bills of Exchange Act and yes, Your Lordship, at 788, if they don't make an inquiry, they must take the consequences. They say, I feel satisfied that the obvious inquiry whether the company had not got its own bank account would have put a stop to the fraudulent system adopted by Underwood. And I don't think it lies in the mouth of the appellants to say that an inquiry would have been useless. This is at 789, in Re Arms Con Charity, Lord Justice Sterling quotes a decision of Lord Romilly, in which he says, with respect to the argument that it was unnecessary to make an inquiry because it would have led to no result, I think it's impossible to admit the validity of that excuse. I concur in the doctrine of Jones and Smith that a false answer or a reasonable answer given to an inquiry made may dispense with the necessity of further inquiry. But I think it's impossible beforehand to come to the conclusion that a false answer would have been given, which would have precluded the necessity of further inquiry. A more dangerous doctrine could not be laid down, nor one involving a more unsatisfactory inquiry, namely a hypothetical inquiry as to what A would have said if B had said something other than what he did say. So they say that it's wrong to argue that an inquiry would have been futile, and they say that that is a dangerous doctrine to go down that line. In fact, here, as I've showed your Lordship, they feel that it would have probably had a chilling effect on the facts of this case, but their position was, and that was the reasoning of Lord Justice Banks, Lord Justice Atkin, where he says at page 798, it was said that if inquiries had been made, Underwood could easily have made a lying explanation, which would have set at rest any doubts. I agree with the judge that even if well-founded, this answer, this would be an insufficient answer. But I think it's more doubtful whether Underwood could have given a satisfactory answer to the above question. Has not the company a bank account? And if so, why are these checks, not these checks, paid into the account? Yeah, a bank can't turn around and say an inquiry would have been futile. We're not going to make an inquiry because we'll just get lies. Banks should make the inquiry and then assess the situation. If the bank are reasonably satisfied, then they can proceed. But as Lord Sumption makes it very clear in the Credit Agricole case, it's not sufficient to prevent a duty of inquiry that there may be a possible innocent explanation. That's not sufficient to trump the duty of inquiry. One has to say, do the transactions promote a reasonable concern to a reasonable payment service provider?
Right, so these submissions are all carried in aid of the submission that the judge had the appeal judge had sound reasons for departing from the factual evaluation based on the reading of the expert's report that the trial judge reached.
Well, yes, Mr. Justice Marcus Smith clearly felt that there were two underlying errors permeating the assessment of the trial judge. First of all, the trial judge didn't view R&D as separate from the fraudsters. But secondly, and perhaps more significant than that, is the fact that the trial judge excluded from his mind anything to do with the regulatory context and money laundering. And that led him to ignore the onboarding process, to ignore the context in which this account was being operated. The only thing that the trial judge did look at was the fact that the Bitcoin account had been opened. He ignored the context, the context of the business account agreement. He ignored the fact that a reasonable payment service provider should have been put on notice by the fact that a fake invoice had been presented during onboarding. I mean, that is, and that Moorwand realized it. The learned judge simply didn't find that at all relevant. And the learned judge, there was a duty of ongoing monitoring, enhanced monitoring in this case. Your Lordship, I've handed up the money laundering regulations. They form the background of to the transaction, and the money laundering regulations provide for initial customer due diligence, but they provide for ongoing monitoring of the account. And in some circumstances, there is a duty of enhanced monitoring. And that arises firstly under the 2007 regulations, where there's not a face-to-face meeting. And then, as the joint expert points out, under the 2017 regulations, it arises where you suspect that you've been presented with a fake document. And as the joint expert said, that is exactly the position here. So there was a duty for enhanced monitoring. And there was a duty for each payment provider to provide a money laundering policy. Now, if this had been we could have pressed for disclosure of the money laundering policy and for their arrangements for enhanced monitoring. But given that we were provided with no information, we're entitled to assume that they hadn't put in place arrangements, a money laundering policy, or an enhanced monitoring process. But that can be the only assumption. They're clearly relevant to their duty. They didn't point to the single joint expert to any information about their monitoring policy or how they operated it, or what arrangements they had for indeed submitting SAR reports. So one has to assume that Moorwand had none of those things. But if they had put those in place, then they would undoubtedly have thought that, as the Mr. Justice Marcus Smith had no difficulty in finding that these transactions, in the light of their previous conduct on the onboarding, would have triggered a duty of inquiry when they see something, transactions that appear to have nothing to do with their declared business purpose. I mean, it's clear that Mr. Justice Marcus Smith, looking at the complete picture as he correctly did, found, one can see it in paragraph 21 of his judgment, found that that he had no difficulty in finding that a reasonable service provider would have been put on inquiry. So really, Mr. Justice Marcus Smith identifies two flaws in the approach of the learned judge. Either would have sufficed on its own to say that the learned judge approached the matter incorrectly. Perhaps the easier to spot on the judgment is to say that he wrongly ignored anything to do with money laundering, and that led him to ignore the onboarding process and all of the background that should have been known. The matters that a reasonable service provider should look at in deciding whether the duty of inquiry was engaged is set out at paragraph 94 in the judgment of Philip. Your Lordship, that is page 825 in the authorities bundle.
Tab number?
Tab number 26.
Thank you.
Where he says says the standard of reasonable, he says at E, the standard of reasonableness provides the necessary flexibility to adapt the principle to different types of crime and accommodate practices and expectations particular to a field of commerce, exigencies of banking practice, such as the vast number of transactions which bank process on a daily basis, and the speed at which, in the interest of efficiency, most banking businesses expect to be conducted, will naturally affect what reasonable skill and care requires. As Mr. Justice Staines said in the Quince-Care case, everything will no doubt depend on the particular facts of each case, factors such as the standing of the corporate customer, the bank's knowledge of the signatory, the amount involved, the need for a prompt transfer, the presence of unusual features, and the scope and means for making reasonable inquiries may be relevant. So it's a factual exercise, but that certainly encompasses knowledge of the onboarding process, what you know about the customer, and I would submit it also involves the background of the regulatory framework, the need for monitoring on the account, and so on. So the learned judge never asked himself, what information would the reasonable service provider have had at his fingertips to say whether or not a duty to inquire was engaged. So that was the first stage of the analysis. What information should a reasonable service provider have had available to him? In the earlier case of East Asia and PT Satria, which is at divided 21 at page 679, at letter C.
Sorry, which page?
Page 679.
Thank you.
So this is in a section in the report headed, "Was P.T. Satcher put on inquiry as to Mr. Yona's lack of actual authority?" So the report, this is decision discussed in Barclays Bank and Philip, and just a single sentence at page 679. The relevant reasonable person is one who has all the background knowledge which could reasonably have been available to the parties in the situation in which they were at the time of the contract. So, in my respectful submission, the learned judge at first instance should have first of all asked himself, what would a reasonable payment service provider have known at the time of these transactions? And in answering that question, he was assisted by the single joint expert, and he would have known, the reasonable service provider would have known of the purpose of the account. He would have known the likely turnover, 100,000 a month, and that is the information that he would have known. So given that this was a marketing consultancy and web designer, that is the background against which these payments should have been judged. And nowhere in his judgment does His Honour Judge Rayside ask himself the question, what considerations would a reasonable service provider have taken into account?
Could we just look together at the expert report again at page 80 of the supplemental bundle? We've already looked at the end of the report.
Yes.
Where there's that rather complicated paragraph in which each proposition has a counter proposition and so on and so forth, and then it's done twice. But if we go to the synopsis paragraph at 1.2, we there see what the expert was being asked to advise about.
Yes. Now, Your Lordship, can I just as a historical fact, this was formulated prior to Philip.
Prior to Philip.
Prior to Philip.
Yes.
So it doesn't completely reflect how matters.
No, but it may be useful in framing the answer.
Yes.
So it was being asked two questions: whether Moorwand's processing of the transfers was in all the circumstances in accordance with practice of a reasonable provider. It goes on having particular regard to its determination of whether transfers were authorised. So that's the first question that was asked. And the second was whether a reasonable payment service provider would have had grounds for believing the transfer were an attempt to misappropriate. And so those are the two questions that he answers in an intermingled way at the end. But your submission rests on his conclusions in relation to whether there was something suspicious about
Yes.
the whole setup.
Yes.
Is the question under 2 the right question
Well, Your Lordship,
for determining what the judges had to determine in this case?
It's not the right question. It's the Quince-Cat question, if I may put it that way. It's not the Philip question. The Philip question is to ask: is there reasonable grounds for believing that the payment is made without authority?
So the point 2, I mean, I'm not
Yes.
expressing a view, I'm just understanding what you're advancing about this, is that question 2 is asking for more than you needed to establish.
Your Lordship, yes, indeed, and indeed this.
So in focusing on question 2,
Yes.
your submission runs, as I understand it, that the judge was similarly asking for more than you needed to establish.
Yes. Yes. This was ordered at the time prior to Philip.
Yes.
And it doesn't reflect the test in Philip. And Your Lordship, that's so. And Your Lordship, the test in Philip that is, I think, one sentence in Philip is absolutely key to the revised test. It is at paragraph 86 of Philip. I'm not sure you were taken to that yesterday. It's a divider 26. It's a paragraph 86 is really the start of his analysis, but so he starts by saying that normally if you've got no reason to suspect a breach of authority, then you're protected by ostensible authority. The last sentence: the doctrine will not protect a third party who has reason to believe that the agent is acting without authority and fails to make inquiries that a reasonable person would have been made in the sense to verify the agent had authority. So the test is no longer, so the reference to misappropriation was in Quince-Cat. And that's why the question asked to the expert is phrased in the way that it is.
But the sole basis here on which it is said that the fake Mr. Stanfield did not have actual authority for R&D is the Brinks-Mat point that an agent does not have authority to defraud the principal.
I certainly don't agree with that. The discussion in Philip that precedes this, absence of authority, is that an agent is only authority to act honestly, and an agent who acts dishonestly towards its principal is acting without authority.
And on what basis is it said that the fake Mr. Stanfield acted acted dishonestly towards R&D because it was misappropriating the
Your
money
Lordship,
for his own purposes
absolutely,
rather than
that
theirs.
is
Well,
clear.
that's what I put to you, and
That's
you
clear.
disagreed with it.
That's clear.
Yeah.
R&D is a trustee. The R&D receives stolen monies that it has to either invest in accordance with the scheme. Well, there is no scheme. Has to return to Mr. and Mrs. Hamblin. Instead, it money launders them away. It's theft.
I don't think we were disagreeing with each other then, Mr.
No.
Smith.
No, Your Lordship, but the point I was making, Your Lordship, in answer to my Lord Justice Peter Jackson's question, was that as to the terms of reference of the expert were framed on the basis of the Quince test, which was a different approach and has been rejected in Philip. And the test that now applies is one, do you have reason to suspect that the person is acting without authority?
Well, in fact, Lord Legate says reason to believe in the paragraph you've just taken to, but Mr. Burns, in his closing paragraph, says reason to suspect. So I think you're dancing on the head of a pin with some of the terminological aspects.
Well, but it's the word misappropriate that I think is no longer is no longer the currency. That's the test is do you have reason to believe he's acting without authority, and that could be for a number of reasons.
Well, it would depend on the case, but I think you just agreed with me that here, as in Brinksman, the reason it said there was no authority is that the money was being applied not for R&D's purposes.
Yes, Your Lordship, but that's looking at it from the point of R&D. In looking at Quince care, one looks at it objectively from the point of the reasonable service provider. And the reason why I say, as to echo what Baroness Hale said, the reason why I say to echo what Baroness Hale said, this is a simple case, is that here you have a company set up for the purpose of web design with a suspected turnover of 100,000. They present a fake invoice during money laundering. They get money in, and 2 weeks later, it's dissipated not in payment of consulting invoices or anything to do with web design or marketing. It's dissipated in Bitcoin and watches in Dubai and 40,000 on motor cars. And the very simple point which Mr. Justice Marcus Smith accepted is, and he had no difficulty in finding that conduct, given the onboarding process, should have put a reasonable payment service provider on inquiry, because the conduct was transparently dishonest, in my respectful submission. Bitcoin were indicative of money laundering.
Yeah, we have them.
You have that point, Your Lordship. Yes, I won't repeat it. So,
doesn't quite answer my Lord's question. I understand you say the word misappropriate comes from Quince-care, and that the correct question now is, do you have reason to believe that the agent is acting without authority, which in the context of a case like this means was acting dishonestly. But what is the practical difference? Your case is that the fake Mr. Stansfield was acting dishonestly and was misappropriating R&D's property, because R&D's property, the only proper use of it was to give it back to Mr. and Mrs. Hamblin. So what's wrong with asking? Was there anything to suggest?
Well,
that there was a misappropriation? Because on the facts of this case, isn't that tantamount to
That is the
asking?
dishonesty.
yeah, but at that time, Moorwand wouldn't have known that. Obviously, they didn't know the circumstances. The question is, were there red flags here that should have put Moorwand on inquiry? And that it might not have been necessarily might not have been absolute misappropriation of the money, but dishonesty in some other ways. I think in practice there would have to be dishonesty, apparent dishonesty. And then at 90, he said, not if there are circumstances suggestive of dishonesty apparent to the bank. So that's the test.
But and I assume if people thought that this report no longer sufficiently addressed the target, expert would have been given some follow-up questions. But on the facts of this case,
Yes.
bearing in mind proportionality, and we're 160,000 in the county court,
Yes.
it came close enough, didn't it, to even after Philip, to addressing the key issue in the case.
Well,
I've got an answer that both of you like bits of.
I do. It depends. But we say that if you actually look at the report as a whole, it flags up that this is indicative of money laundering. The transactions are not in accordance with the stated purpose, are not consistent with and the report, fairly read, says that there were red flags here that should have triggered the duty to inquiry.
Well, I think on your interpretation, there's a flat inconsistency within a single sentence in the concluding paragraph, because you say it follows from the last bit that there were grounds for suspicion of misappropriation, but people rolled the dice in not calling the expert that might have ironed out that inconsistency, and the judge was left to reach a view, with each of you saying the report supports me.
Yes, well, Your Lordship, we go back to the question of whether the judge had put on blinkers when he read the report by saying that any reference to money laundering was irrelevant.
Well, the blinkers do not address what, on your case, is a fundamental inconsistency in the closing sentence of the report.
Well, Your Lordship,
you're not saying the expert's wearing the blinkers.
Well, if Your Lordship just looks at that last sentence, I don't think that sentence is qualified by the reference to money laundering. Earlier, even in that paragraph, he says that it's not consistent with the declared purpose of the transaction. And then he in his discussion says that he was put on inquiry. So he says that the bank should have made inquiry.
We're going around in circles. You quite rightly continually point to the bits that you say
Yes.
support you, as you did before the judge, and no doubt Mr. Salter in reply is going to
Yes.
point to the bits that Miss Knight pointed to that supported. She said supported her before the judge, and we've got the report with those different bits in.
Your Lordship, I say that the learned Mr. Justin Marcus Smith was entitled to make a re-evaluation because of the flaws that he identified in the judge. That there were.
Now, you say there were two, and we do have. You say those are the two entry points, and if you're right about that, even though you one of them,
Yes.
he gets to revisit the discretion, and if you're wrong about them both, he doesn't, and that's what it comes to.
Yes, I think essentially there are two he identifies. I think that I have made a wider point that the regulatory framework is something. I mean, is something that was relevant and that the learned judge should. So that's not a point actually made by Mr. Justice Marcus Smith. That he says that facts ascertained through money laundering are relevant. He doesn't look at the requirement for ongoing monitoring, the requirement for enhanced monitoring, which I think is reasonable for, should have been part of the consideration of what a reasonable service provider would have. So he doesn't draw attention to that. But I do say that he was right in the two respects that he addressed, and which he elaborates in subparagraph 7, and he finds it a simple, straightforward matter. Yes, so if your lordship, I say that His Honour Judge Rayside didn't approach it correctly. I say that Mr. Justice Marcus Smith did approach it correctly. If you find that Mr. Justice Marcus Smith didn't approach it correctly, but that there are that say that His Honour Judge Rayside was wrong in his approach to onboarding and money laundering, then the evaluation will be a matter for this court. And I would invite the court to say that there were obvious inconsistencies between so your lordship, points were made yesterday that it was impractical to have a system of inquiry. Well, your lordship, I say that I've already submitted in my note that there's no evidence for that. There's undoubtedly a regulatory duty of ongoing enhanced monitoring. How is that to take place? It must involve an internal procedure that is in place. All banks have, and then banks have to consider the obligation under the Proceeds of Crime Act. That involves an intervention in the banking process as appropriate. But no evidence was put in as to what their procedures were or how they were operated. So, in the absence of such evidence, one has to assume that it was practical to intervene and to make inquiries. The evidential burden certainly didn't rest on the Hamblins to say that, to prove that it was evidentially practical to intervene, because they don't have the evidence, and Moorwand do have the evidence and didn't submit it.
Yes.
So, your lordships, I was going to take your lordships to the cases that you were taken to yesterday that deal with the authority of whether the fraudster bind.
I'm just wondering, as this appeal has gone on, whether that point is really live, because no positive case was advanced by Moorwand of actual authority before the judge. There was a non-admission simply of your position. The judge finds effectively ostensible authority because that's the consequence of finding no duty of inquiry. If Mr. Justice Marcus Smith was entitled to revisit that and his findings stand, then there is no ostensible authority. And I'm just wondering whether, for all the intellectual interest that the point might appear to offer, whether it's actually engaged, given the way in which this case has been argued and decided on the way here. Now, if I'm wrong about that,
well, Your Lordship, I think Your Lordship is correct, because I think that even if the fraudster was a director, that doesn't make any difference. The director has to act honestly and has to act lawfully, and if a director doesn't act honestly and lawfully, then the director is acting outside their authority, and the Philip duty or Philip obligation or is engaged. So I accept what Your Lordship says. I don't think the authority point is critical, except that the judge doesn't distinguish between the company and the fraudsters, and that is a very important.
since we've been through whether that is an entry point for Mr. Justice Marcus Smith, that's your ground one of the two
Yes.
errors, and we've had submissions.
And I would say, so my learned friend sought to distinguish Brinksmat. I say it's indistinguishable.
Yes, I mean, would it be, just thinking about the practical way of dealing with this, would you like to give us your short submission in relation to those authorities so that we have a note of it,
Yes,
rather than necessarily going to it in great detail?
yes.
We can ask you to do that if prompted, but what would you like
I
to note
would say
about
that,
the indistinguishable Brinksmat?
I say Brinksmat is indistinguishable.
Is Brinksmat an actual decision on the point, or just the decision that permission to amend should be granted?
No, I think it is a decision. They
Do you want to show us the relevant parts?
Your Lordship, yes.
Tab 5.
Tab 5. So, Your Lordship, so your Lordship aware of the facts, that is, Scanlon was incorporated, the directors were fraudsters. One sees that at paragraph, page 69 on the right-hand column. Small company, and then further down, Scanlon was used as the medium for disposing of the stolen gold and its proceeds. Chappell and Palmer would take part in the smelting operation, caused Scanlon to sell the product to various companies purchasing in good faith. And then they drew large sums in cash from the account in ever-increasing amounts. And the claim against the bank one can see from page 71 at 11.9 so it was a similar case. Barclays were in breach of the duty of care which they owed to Scadlin. As aforesaid, Barclays knew or ought to have known that the persons who gave Barclays the instructions the said payments be made and or the individuals into whose hands the money was placed alternatively might well be acting dishonestly in breach of their fiduciary duties to Scadlin by misappropriating Scadlin's funds. Barclays did not make any proper inquiries or take any proper precautions to ensure that the individuals to whom the money could be trusted to dispose of it. And then they go on to set out the pleading and then the argument is set out at page 72 under little a. I believe this is there are special features appear to be twofold. In the first place is the fact that Powell and Chappell owned the shares in Scadlin and in practice controlled what it did. I believe this is prayed in aid in more than one way. A, the corporate personality of Scadlin should be ignored so that the company can be identified with the two dishonest men. Anything which the company did, they did, and vice versa. Thus Chappell and Powell were the true customers of the bank and were doing no more than draw out their own money. However strange the circumstances might look, there was no possibility of impropriety as between the person making the withdrawal and the titular account holder. And then he deals, the learned judge, Lord Justice, deals with that on the left-hand side. As to the first of these objections, that is, lifting the corporate veil, no authority was cited which comes remotely close to sustaining it. I'm not surprised, for the proposition ignores the fact that a limited company is a body which has not only subscribers but also creditors with legitimate claims on its assets. Here the corporate entity was Scadlin, and however odd the notion may seem at first sight, the victim of wrongful arrangements to deprive it improperly of a large part of its assets. If the facts were such that the bank should have recognised the possibility of such an impropriety, and if the scope of the bank's duty of care was wide enough to impose an obligation to take steps to forestall it, I see no reason why the cause of action should not be enforced by Scadlin for the ultimate benefit of the creditors who would look to those assets for satisfaction of their debts. And then right at the bottom, if one now proceeds to add the second special feature of this case, namely that the monies credited to Scadlin's account were impressed with a trust in favour of Bank Binksmat, just the same position as here, the matter becomes even more clear, for this additional factor means that Scadlin as trustee was under a duty to account to Binksmat and Johnson Matthew as their respective interests might appear, and the ability of the company to comply with this duty became progressively diminished as the money was wrongfully bled from its account. It seems to me plain that the acts which created the situation were wrong as committed by the two men against the company, and the fact they also controlled the company is entirely beside the point. On the facts which were being assumed for the purpose of the appeal, the bank would not have been expected to know that the funds with which the two men were dealing belonged not to Scadlin, but to others. Then the facts are enough to make it arguable. And then Lord Justice Nichols is to the same effect at page 73 in the left-hand column. On the facts alleged in the proposed amendments, Scadlin was at all material times being used by Chappell and Palmer and others for a fraudulent purpose to realise the proceeds of sale of the robbery. But the plaintiff was not implicated in any such fraudulent purpose. On the contrary, along with the owners of the gold, the plaintiff was the intended victim of the scheme. Likewise, Scadlin itself was an intended victim, in that Scadlin was used as a vehicle for committing a fraud on its creditors and a fraud on those beneficially interested in property held by Scadlin. In those circumstances, the fraudulent purpose of those controlling Scadlin are not to be imputed to the company itself. Citing Belmont.
The report doesn't tell us when Scadlin was set up, does it? Or how long it had been trading, if it had been trading before it became used.
I don't think it does.
No.
I think that I don't believe the reasoning of the case hinges on that particularly.
No, but I know. Just of interest in the context of saying that it's indistinguishable.
Well, my learned friend said that there was a distinction between Scadlin and R&D in this case, because he said Scadlin had a legitimate, had a business, and R&D didn't. I don't accept that.
It forms no part of the court's reasoning.
No part of the court's reasoning, and I don't accept that as a valid distinction. The principle behind the case is clear And the court accepts that it's a strange conclusion, perhaps, to somebody who's not versed in corporate, the rule in Salomon and Salomon, a strange conclusion. But the company is a victim. Company is a trustee, owes obligations to the Hamblin. It's being stripped of its assets. It can't fulfill its obligations. But then on the right-hand side, I see no justification for ignoring the existence of Scadlin as a legal entity when considering the claims, if any of which may lie against Barclays. I'm unable to accept Mr. Thomas's submission that the veil of incorporation should be stripped away and the bank's position be the same as it would be if the account had been in the name of not Scadlin, but in the name of the two individual shareholders. So
that it is a curiosity of your case that if the fake Mr. Stansfield had opened an account in the name of an individual, his own name or a fake name, you wouldn't have this claim. It's the fact that there's a corporate customer,
yes,
which entitles you to bring this claim.
However many deserving creditors the fake Mr. Stanfield would have had,
yes,
if he'd opened the account himself.
Well, Your Lordship, I can only reply by
Baroness Hale in singular.
by referring to Baroness Hale. Companies have separate wills, they have agents. Yes,
And
but
also,
I mean, I think if
I mean, it doesn't mean there's anything wrong with your case.
No.
But it is, as pointed out by Lord Justice Nichols, it seems slightly odd that because the two crooks in that case chose to use a limited company to smelt the gold and sell it and launder the proceeds, the claimants, Brinksmat, are in a better position than if they'd done it in their own names.
it
Yes.
would also mean that if you were able to bring yourself within one of the categories in pressed for piercing the corporate veil, the cause of action might disappear.
well, I'm not
And
sure about
using the
that.
company as a vehicle of fraud has, gets some airing in that context. Perhaps
Well,
there would be two causes of action in that scenario. I don't know.
well, your Lordship, maybe, but Lord Justice Nichols said, I recognise that given the background of the robbery, to speak of fiduciary duties owed by Scadlin to Chaplain Palmer has a very hollow, empty ring in the sense that there was never any question of Chaplain Palmer implementing any of those duties. But in my view, however, if and to the extent that Bullin was held by Scadlin on trust for the plaintiff, the appropriation by Chaplain Palmer of their proceeds for their purpose was in law a breach of fiduciary duty. And Your Lordship, I think I do rely heavily on that case, and as Mr. Justice Marcus Smith said, I believe that it was entirely orthodox. It was approved by all members of the court in Burla and Nazir. They all refer to it. I say my skeleton was only referred to by Lord Sumption. That's wrong. It's actually also referred to by Lord Toulson and Lord Hodge. It's all approved.
Is that in the sense of it's cited without criticism,
Well,
without any exploration of the company as creature of fraud?
well,
Certainly no one says it's wrong.
no one said it wrong. At paragraph 177 at page 455, which is not a reference I put in my skeleton, Lord Justice Toulson and Lord Hodge say, in Brinksmat and Noy, one of the arguments advanced by the bank was that Scadnin suffered no loss because it never had any property of its own and held the proceeds of the bullion on trust. The argument was dismissed. Lord Justice Nichols observed that the director was much of a breach of fiduciary duty which owed the company if he misappropriated, to which the company was a trustee if he misappropriated property belonging beneficially to the property. So, well,
It's a narrower.
well,
narrow, isn't it?
if they've had any doubt about the case, they would have undoubtedly expressed it.
That reasoning is a very good reason to refer to as few cases as possible in any judgment.
Well, there's certainly no doubt cast on the case in Berner and Nazir, and the decision of the Supreme Court in Singularis, although they don't refer to the Brinksmat case, is completely consistent with it. They say in that case that the director who directs the funds is not to be attributed to the company. And they also, we had a debate about illegality yesterday. Baroness Hale also says that the illegality defence will not succeed. So,
But I understand that you have a preliminary point on that, which is it's simply not open to Mr. Smith.
I do. I do.
Because it wasn't
not open
really-
to them. Could have put in a respondent's notice. Didn't do so. Not considered on appeal.
Yeah.
But
Nor raised in the grounds of appeal to this court.
not raised in the grounds of appeal to this court. And frankly, even if it had been, Singularis is a clear authority, A, against attribution, and B, against illegality applying in this case, because if you had an illegality defence and you had an attribution, then the whole function of the rule, I know she spoke in terms of, the Supreme Court spoke in terms of quintscap, the reasoning was translated.
Denudes the rule of any content.
Indeed. So, Singularis was cited to His Honour Judge Ray's side. He doesn't refer to it particularly, but it is, I would submit, indistinguishable again, and is clear authority against attribution and illegality. Also, if I might just look at my notes. Yes, there is a line of authority. I don't think it's necessary to go into it in detail, that says that any if a director acts unlawfully against the law dishonestly, then it can't be ratified because it ultra vires the company. It can't be attributed to the company. That's the case of Mr. Justice Zaccaroli in Tonstate of Wojcicki. It's in the bundle. It's to the same. I think it just underlines the fact that if somebody acts illegally and improperly, then it's not within the authority of the company, and it cannot be ratified by the company under the duomatic principle. That, in a sense, further underlines the fact that you can't attribute dishonest conduct to the company. It's made without authority, and Your Lordship, that's in the bundle. Yes, just another small point, Your Lordships, that there is cited a case in the skeleton argument of my learned friend. You weren't actually taken to it, for the proposition that money laundering regulations don't create a civil remedy, which I accept, but that case makes it very clear that they can form the content of a civil duty of care. Yeah. And if I may give Your Lordships the reference, it's at paragraph 18 or at divider 11, page 362, the case of Green and Rowley, there's also a statement to that effect in P&P and Owen White and Kaplan, a case to which you were taken, paragraph 31. Green and Rowley at 18, page 369, makes it clear that, as I would submit, is common sense, that when you're looking at the duty of care or a duty of inquiry in a particular situation, the regulatory is part of the landscape. The regulatory provisions are part of the landscape, and it's an error of law not to take them into account. And that's an error of law, I say, the judge made here. I refer to a very old case about a rail accident where there was a provision of a regulation requiring safety handholds to be provided. It didn't itself create a claim in breach of statutory duty, but it was relevant in looking at whether or not the railway company had been negligent.
Yes.
Your Lordship.
Interest.
Thank you. I'm grateful. Well, what I said about that is, well, first of all, it's conceded that the banking relationship came to an end on dissolution of the company, which was in July 2018. That's actually set out in the grounds of appeal. So it's common ground that is a start date. I say that...
so when the banking relationship comes to an end, at that point the debt crystallises and becomes due.
Yes,
without demand.
Without demand. That's in
because the ordinary, the general principle, you no doubt don't take issue with, that with an ordinary current account in credit, the money doesn't become due until you ask for it. That's not in dispute.
No, that's not in dispute.
But the premise of that is that it's a running account, and therefore, as long as the account is open, time doesn't start running effectively.
Yes.
But you say it follows from that. When the company is dissolved and the contract necessarily comes to end, the debt crystallises and becomes due at that point without
Yes.
demand.
Yes.
Due to who if the company has ceased to exist?
Yes.
Well, it's due.
Bond of accounting.
It's Treasury solicitor, yes.
Due to the Treasury solicitor who hold it on trust for my clients.
And restoration, is that retrospective? And does that revive then the banking relationship?
Well, it is. It can be retrospective. The court can give directions. It says it's generally retrospective. I would say that where the dissolution takes place, there's no guarantee company is going to be. I mean, I think that's a difficult question, but I think that the banking relationship has come to an end with dissolution. There's no guarantee at the time of dissolution that it's ever going to be restored or when it's going to be restored. So the banking relationship has come to an end at that point. That seems to be accepted, indeed, both in the skeleton argument of my learned friend and in his grounds of appeal. So, and it's supported by Paget. I would say with the judge that incorrect statements were issued here, and that does trigger a cause of action. But I accept that that is slightly the conventional answer would be to say that a demand is necessary.
Your only cause of action on which you succeeded was non-payment of the true credit standing to the account, the restoration of the account.
Yes.
It's quite difficult to see how you can be better off on that cause of action than if the money had never been debited. If the money had never been debited, it would have just stayed in the account without interest.
Well, the fact that it's not earning interest, in my submission, is it's not an unjust enrichment. Not an unjust enrichment claim for interest. It's a claim under Section 35A of the Senior Courts Act, which
but that's generally treated as having a compensatory function.
Yes. So I say the money shouldn't have been debited, and should have been paid to us when it was debited. As a fallback position, I say that the banking relationship came to an end on dissolution, which happened not very long afterwards, in July 2018. And as a fallback beyond that, well, I don't need a fallback beyond that. We did serve a letter before. We served a letter before claim 2019.
Yes, but that wasn't an assertion in the name of RND, that was an assertion in the name of Mr. and Mrs. Hamblin.
Well, but they were the beneficiaries. I say that if money is held on trust for somebody, a demand by the beneficiaries should be sufficient.
Is an award of interest a discretionary decision?
It is, George, yes.
Right, so the judge can take a broad look at this. I mean, say, for example, you say instead of the money being spent on watches, it had been given back to you. You'd have had opportunity to use it.
Well, I'd like to agree with your lordship, but
I'm wrong in that case.
I feel obliged to say Section 35A says from the time that the cause of action commenced.
Yes.
So you have to...
That's the difficulty you're facing. The argument being the cause of action didn't commence until you made a demand, or you
Yes, it's a surprising rule, but I have to accept that because it appears in the limitation context that the bank, claim against the bank, crystallizes with a demand.
I just wonder though, because English law has chosen to treat a claim about a bank wrongfully debiting an account as a claim in debt, and it allows the customer to sue It's very odd to say that nonetheless the customer doesn't have a cause of action. Now, I can see an argument that the compensatory function of Section 35A might mean you say, well, let's go back to where we would have been, and it would have been in an account, and it's not an interest-bearing account, interest wouldn't have been running. But I find it quite odd to say you can get judgment on a debt claim on this hypothesis without having a cause of action.
Well, the technical argument advanced by the appellant is that the authorities say that the cause of the shows in action doesn't crystallise until the demand is served. But I would say that it is an inchoate cause of action. The fact that it's contingent shouldn't prevent an award of interest. And in practice, the accounts were debited wrongly. The account statements are in the bundle. They were debited, wrongly debited, and the wrong debiting should be a cause of action. I think the current rule is very counterintuitive.
On the other hand, I mean, it may be that it is a breach of contract, and it may be that if you could show damages, you could sue for damages. But then you run into the problem of the terms and conditions which exclude any liability for damages. So you couldn't bring, the reason you can succeed in your claim, if you can, is because it's a debt claim. And that is because, as Mr. Justice Marcus Smith explains, the remedy is to reconstitute the account. And it doesn't seem to me very surprising if that's the route by which you can get the money, is by reconstituting the account, but it should be subject to the same limitations as if the money had been in the account in the first place, namely that it doesn't accrue due until you ask for it. That's I mean, that's where I think we are. But I see. Well, I think we have your arguments to the contrary.
Yes. Yeah. Thank you.
Can you just tell me, as a matter of interest, how much turns on this point?
What, the interest?
Yes. How much did you get in?
Well, quite a lot. In the order, mate.
Yeah, it was 2% over base.
2% over base for
It's in the messages.
9 years. Well, of course, if I'm right about the
Sorry for talking over you.
Sorry.
9th of June 2025, it was £48,758. So,
But Your Lordship, if I'm right about the date of dissolution,
You'd get the bulk of that anyway.
we'll get the bulk of that anyway.
And even on Mr. Salter's argument, I think he accepted that at the latest a demand was made just before the claim in 2022. So you'd still get 3 years of that on any view, I think.
Yeah, well,
So that's what we're arguing about. Thank you.
yes.
thank you very much, Mr. Hilton. Very well. Now, Mr. Salter, we'll return at 2:05 for any reply. How long do you expect to be?
I would hope no more than 3/4 of an hour.
Thank you. 2:05.
Authorising table.